from the Department of Consumer and Business Affairs Mediation Unit. Thank you for joining us for today's webinar, Debt Settlement Mediation. Next slide, please. And before we get started, I want to inform you that there will be a Q&A session after the presentation. Your microphone is deactivated, so you will not be able to hear. If you have any questions, use the chat box located on the lower right-hand side of your screen. Your chat icon should reflect the icon you are seeing on the screen. This webinar will be recorded and will be available on our YouTube channel for your convenience, where you will also find additional presentations that we recorded in the past. Next slide, please. At the conclusion of the presentation, you will have the opportunity to complete a survey. We really encourage you to complete it, as it does help us to better your experience for future webinars. You don't have to do anything to generate the survey. It will generate on its own once the webinar is concluded. Now I would like to introduce you to your presenter, Tanzila Huda. Tanzila?
Thank you, Christina. Can everybody hear me all right?
Yes. Yes.
Okay, thank you. So good afternoon, welcome everyone. My name is Tanzila Huda. I'm a staff mediator at the Los Angeles County Department of Consumer and Business Affairs Dispute Resolution Program. Today's webinar is on settling debt cases or mediating debt settlement cases. If you are a consumer struggling with debt, I hope you will find this webinar to be very helpful to you, and it will give you hope. Our department has successfully mediated hundreds of debt settlement cases, and our services are completely free. Okay, so let's get started. And again, thank you very much for joining us today. So let's start with the first. Slide. We can go to the next slide. Okay. So first thing, what is consumer debt? Consumer debt consists of personal debts that are owed for purchasing goods for individual or household consumption. Credit card debts, student loans, auto loans, mortgages, and payday loans are all examples of consumer debts. Some people get into debt for necessities they need for everyday life. If someone moves into an apartment with no refrigerator and they have no money, they are forced to pay with credit cards or open a new credit card, especially if the retail store offers credit card accounts to new buyers. So if a person needs a car for transportation, they may get an auto loan. So notice how easy it is to fall into debt. Next slide, please. Before we get into mediating debt settlement cases, let's try to understand why we need to do that. There are many reasons for that. And we also need to bear in mind that there are lots of negative effects of debt. So debt can have a very negative impact on your life. And let's look at some examples. Debt can take a toll on your emotional and mental well-being. Imagine what it feels like to worry every month about not being able to pay your bills or running out of cash. Harassing phone calls from bill collectors can severely stress you out and put you in a state of constant anxiety and fear. There are studies that show individuals who struggle with debt also suffer from anxiety, depression, and sometimes even suicidal thoughts. Physical health. People burdened with debt may find it difficult to fall asleep or get rest or relax. They may experience muscle tensions or body aches, like backaches. The stress may affect their ability to perform effectively at work. Interpersonal relationships. Debt may have a disastrous effect on personal relationships. There is something called debt shame. It is the shame someone feels when they're struggling with debt. A debtor may avoid talking about debt because they don't want to be judged. Shame prevents people from disclosing their debt problems to their loved ones or seeking help with the debt. Often the secret about the debt comes out only when the debt has spiraled out of control, resulting in arguments with family members, distrust, blaming, and even breakdown of relationships. And finally, financial health. Debt could seriously damage your financial health. Carrying a lot of debt, especially high credit card debt, hurts your credit score and your ability to get approved for new credit cards, loans, or to increase your credit limit. If you have a lot of debt, you might experience difficulty in paying your bills. You might end up borrowing money from your relatives or friends. So this is a classic example of borrowing from Peter to pay Paul. You eliminate one debt by borrowing money, but then you incur a brand new debt. So it's a cycle that it's difficult to get out of. So you might have to max out your credit cards to pay your basic bills. Having bad credit may also affect your ability to get a job or rent an apartment or a home. Next slide, please. Now, common options for handling debt. The three most common options for managing debt are: number one, negotiating directly with creditors or collection agencies. Number two, hiring a debt management company or filing for bankruptcy. So let's start with the first one, negotiating directly with the creditors, with your creditors or collection agencies. So suppose a debtor decides to directly negotiate her debts with a collection agency. After all, the bill collectors are calling her daily, so she might or he might decide to talk to the bill collector and try to work something out. She may also wish to explain why she fell behind or he fell behind on his or her payments and plead for debt forgiveness or at least some debt reduction or some extra time. Now, bill collectors, on the other hand, are intimidating and hostile. That's what they're trained to do, trained to be, and not the least bit interested in hearing about the personal problems of the debtors. Their only goal is to collect money. The process of negotiating with collection agencies can be overwhelming and stressful for people who are not familiar with negotiation tactics. Okay, negotiating good agreements, mediating is an art that requires training and experience. The average debtor may not be able to pull it off effectively to their own advantage. Okay, so if you don't have experience negotiating, you may not get the best deal. Since bill collectors tend to be rude, that's what's expected of them. That's really what they're trained to be, and they're constantly threatening to sue you. A debtor might get very intimidated and get scared and accept a very bad deal. So that's why you need a mediator. Mediators are trained to listen to your side of the story, to learn about your needs, and then negotiate the best deals they can get for you. They will try to work out a settlement plan that is mutually accepted by both the debtor and the creditor. So number two, hiring a debt management company. Debtors may get overwhelmed with direct negotiations and they may hire a debt management company for help. So debt management companies, what they do is they work out a payment plan with you, and they will make payments on your behalf. So you pay the debt management company, and they will pay your creditors, and they will help work something out, and they will charge you a fee. The fee depends on the company, but it could be something like 20% of the principal, or say 15% of the debt that is forgiven. A concern with hiring debt management companies is that you have to be very careful. Just read the news and you will find that countless stories about fraudulent or unscrupulous debt management services. So I want to give you a personal example. I have a relative who set up a monthly installment payment plan with a debt consolidation company. She had several credit cards that she was finding very difficult to pay, so she went to this debt consolidation company. She used to send them $1,000 a month, and they were supposed to send the payments to her various creditors. Now, last year, she was sued by two of her creditors, and she was very puzzled because she was making monthly payments. Then she found out that the debt management company stopped sending her payments to the creditors. So this caused her to default on the payment plan, and then that's why she got sued. So I'm not saying all debt management companies are unscrupulous, absolutely not. They're wonderful companies, but I'm just strongly encouraging you to do some research and read some reviews before signing up with the debt management company you want to work with. The last is filing bankruptcy. This is a complex topic, so I'm not going to go too much into it, but basically filing for bankruptcy may have a big negative impact on your credit report. There will be a public record of your bankruptcy. It may impact your ability to rent a new apartment or apply for a new job because potential landlords and employers will review your credit report. Okay, next, please. Okay, so mediated debt settlement. What is mediation, first of all? Mediation is a confidential, dialogue-based process where a neutral and impartial third party or a mediator assists two or more parties to resolve their disagreements. The parties voluntarily participate in the process. Why mediation works better than the other options, or it's an excellent option, really, is because the currency of the mediator is trust, that people trust us. And they trust us because we are neutral. We don't take side. We don't take sides. So, if you try to work out a deal for you, it'll be fair to both sides. The interests of both sides will be taken into account. And that's why people like working with us. So what is the mediator's role? A mediator is a neutral and impartial third party who will guide the mediation process. They help the parties tell their stories and express their needs. They carry messages, offers, counteroffers, and demands, and they help the parties understand each other better and work out a solution that is mutually acceptable. Next, please. Excuse me. Okay, so there are two types of debt settlement cases that we handle, or we can put them in two types of categories. One is non-litigated category, and the other is the litigated category. So the non-litigated category is early on in the journey of your debt. So you owe money to a credit card company or a bank. But you have missed payments. You're having money trouble, and you're missing payments. Collection agencies are calling you, and they're as demanding payments, or they're threatening to sue you. They're sending you demand bills, but they have not sued you yet. Okay, so that's why it's non-litigated. Nobody has sued you yet, but you're at great risk of being sued. So if you come to us at this stage, at this early stage, our goal, the mediation program's goal, would be to help you and the creditor set up a payment plan so that you don't get sued by them. Once you complete the payments, the creditor will close your collection file. In fact, if you make installment payments, they may immediately stop calling you and bothering you, so you'll have some relief from the daily bill collectors calling you and harassing you. And if you complete all the payments, your file will be closed, and then no one goes to court. Now then there's the other category, okay? So you owe money, you're having difficulty paying your creditors, they're threatening to sue you, and then they sued you, okay? That's why it's litigated, because somebody filed a lawsuit against you. But what happens is the trial doesn't happen the next day. Somebody files a lawsuit, and if it's in civil limited court, it may be a year or a year and a half before the trial takes place. So there's that time space, the time you have between being sued and going to the trial. So this is when you come to us. So if you come to us at this stage where you have been sued, but the trial hasn't taken place, our goal would be to help you set up a payment plan with the creditor so that after you're done paying, the creditor will dismiss the lawsuit before the trial takes place. So the trial is a year and a half from the date you were sued, and you spend that time that you have in paying off your debt. And if you're done paying, the creditor will dismiss the lawsuit before the date of trial, so nobody goes to court. Now, the second type of litigated debt settlement case is that you were sued and you went to trial and you lost. So the creditor won the lawsuit, and they won a judgment against you. So there is a judgment against you. You're probably hoping at this stage to improve your credit scores, or you're trying to stop wage garnishment that might be happening because there's a judgment and they're trying to collect money from you. So if you come to us at the stage where there's a judgment against you, our goal would be to help you set up a payment plan with the creditor to pay off the judgment. Once you're paid in full, the creditor will file satisfaction of judgment with the court, or they could stop garnishing your wages. So if you want more details about how that works, I would refer you to our small claims advisory program. It's a unit within the Department of Consumer and Business Affairs. But either way, you could negotiate a settlement term where the creditor will agree to notify the credit reporting agencies that now you're taking financial responsibility and you're making payments. So this helps you start a new life, after you're done paying the judgment, and you can move on with your life. Okay, next, please. Okay, so how to submit a mediation request. The process is really simple. You see the address on the slide, dcba.lacounty.gov. So that's where you want to click. That's what you want to type in. And you click mediation, then you click request mediation, and then you fill out our online application form. The online application form, when you fill it out, it will ask you for your contact information. It will ask you for the contact information with the party you're seeking to mediate with. So in your case, you're trying to mediate with your creditor. So you want to type in the contact information of the law firm that represents the creditor or whoever is suing you. So you want to give their information so that we can reach out to them. And there'll be space for you to describe your situation. So you want to, you don't want to give too much information. You can just say you have bills that you've been unable to pay, and you can give a little bit of information about what happened, why you're not paying. And then you want to, it will ask you, what is your desired resolution? And your desired resolution, just write simply something like you want to settle the debt dispute, you want to work out a payment plan. So you want, say what you want, so that because that your application form will be sent, will be actually mailed to your creditor, to the person you want to mediate with. So they will read what you're asking for. So that's why, you want to write a clear description of, what your situation is, but keep it brief and also say what you want. Next, please. Now, third-party authorization form. After your online application is processed, somebody from the office, probably it will be me, who will email you a third-party authorization form. It will be emailed to you, and we will be asking you in the email to fill it out. By completing this third-party authorization form, you're giving permission to your creditor to discuss your financial situation with the mediator. So you need to provide 5 pieces of information in the third-party authorization form. You have to provide the name of the creditor or the law firm that's suing you, your account number or the lawsuit number, your birth date, the last 4 digits of your social security number, and your signature. Next page, please. Okay, so the processing of your application. So after you submit your application, we will process it. What we do is we process your application, we assign a case number to you, and then we create a mediation packet, invitation packet, which we mail to the creditor, and we wait for their response. So basically, the packet will inform the creditor that you requested mediation, that you want to work out a debt settlement plan, and it'll have information about our mediation program, so they know how to get in touch with our program and get started. If the creditor is a big corporation, they will have lots and lots of clients, so it may take a month or a little bit extra time for them to respond, because they may have a lot of people requesting mediation with them. So we just urge you to be patient. We suggest you use the time period that you wait for the creditor to get back to us. You can use time to provide some documents that will help your mediator understand your situation. You can log into our portal, the DCB portal, because once you send your application, a PIN code will be sent to you, and you'll be able to log into our website, and you'll have your own account, and you can upload documents. So here are some suggestions of documents that you could upload. A copy of demand letters from collection agencies or law firms, copy of summons if you have been sued, loan agreement, letters from law firms or attorneys representing the creditor, invoices, credit report. So sometimes the debt is sold to other companies, and you're getting calls from bill collectors, but you're not sure who the creditor is because you have multiple cards and you don't know who this bill collector is calling on behalf of. So reviewing your credit report will help you figure out who the creditor is. Your credit report will have their phone number and other contact information, and you can provide that to the mediator. Next, please. So what does the debt settlement process look like? So a mediator, after we process your mediation application and we send out the letter to the creditor, A mediator will be assigned to your case. The mediator will, after the case is assigned, the mediator will either call you or email you to introduce himself or herself to you, and they will ask you questions about your situation. They will want to learn more about what's going on, and the mediator will help you work out a debt settlement plan. So there is something I want you to note, that please note that the first step in mediated debt settlements is that you accept the debt and then you take ownership for it. So if you believe that you were a victim of identity theft, or then mediation may not be the right thing for you, because mediators are not fraud investigators. If you think that you don't owe a debt, then and that's a fraud, then you don't want to ask for mediation, because mediators wouldn't be able to help you in that situation. So request that settlement mediation only if you agree that the debt is valid and that's your debt and that you want to pay it off. So what is debt settlement? The debt settlement mediation allows debtors and creditors to come to a mutual agreement that settles the debt. It is an arrangement between a lender slash creditor and a borrower slash debtor to pay back the debt that is owed. Next, please. The debt settlement offers. There are basically two types of debt settlement offers, and there could be others, but these are usually the two types that we deal with. One is the one-time lump sum payment, and the other is monthly installment payment plan. So let's start with the one-time lump sum payment. The debtor makes an offer to pay 70 or 80%, sometimes even 50% of the outstanding debt in a one lump sum payment. If the creditor accepts the offer, then the rest of the debt is forgiven. However, most people usually can't afford to make these types of settlement offers because it requires having a large amount of money lying around. And if you're already in debt, you may have cash flow problems, and this may not be an option for you. So some debtors choose this option, but there are debtors who choose this option. Usually I learn from them that they've received a big tax return or inheritance, and that's why they want to make this kind of offer. There are also some clients who told me that, in order to make one-time lump sum payments, they stop making monthly payments and to save up for one lump sum payment. So the problem with the strategy is that the interest and penalties will add up, and you risk getting sued while you're saving money. So be careful about this strategy. And again, what I'm trying to tell you is that there are some clients who have informed us that they only want to do one-time lump sum payment. They want to be done in one go. They don't want to do monthly payments, but they don't have enough money for the one-time lump sum payment. So what they do is that they stop making monthly payments that they're supposed to be making, and they save that money. And then they contact our mediation program to make a one-time lump sum payment. So what I'm cautioning you about is that they, while all the months that you're not paying, you will have penalties, you'll get interest, and you might get sued in that time. So be careful if that is a strategy you want to follow. The alternative to one-time lump sum payment is monthly installment payments. So if you cannot afford to make a lump sum offer, your other option is to make this kind of offer, the installment payment plan. You will pay your entire debt off in equal monthly installments until the debt is paid in full. Next, please. So let's go over some factors to consider for successful payment plans. Review your finances and make a list of your living expenses, your mortgage, your rent payments, your utility bills, car bills, gas, food, entertainment money / fund money. So what are your, and then you want to look at your sources of income. Where is the money going to be coming from? Figure out how much you spend every month on your necessities. Create a realistic monthly budget. Ask yourself if you can really manage to live on that budget, because the remainder is going to go into your debt payment. Don't stretch your budget too thin with no money left over for living expenses, or what will happen is you will end up defaulting on the settlement agreement. So you don't want that to happen. It has to be something that you can keep on paying until you're paid in full. After creating the budget, you may find that you really don't have enough money left over to make a settlement offer. If that is the case, then I would like to share what some of my clients have told me that they did. So here's some examples from my clients. They took a second job or a part-time job for the debt payment period. So they got another job and they got some extra cash from the job and they put that into the monthly installment payments. Or they eliminated expenses such as gym memberships, magazine subscriptions, shopping, eating out. And also they said that they sell off some personal belongings to raise cash, or they go to, they hold yard sales, garage sales, and they sell old clothes, furniture. So they sell something to raise cash. So think about that. That is some strategy. That's a strategy some people do, and it works for them. So please make realistic settlement offers. Make an offer that you can really afford to make. You should feel reasonably certain that you will not default on the payment plan. Remember that settlement agreement is a big commitment to your creditor, and most importantly, it's a commitment to yourself. Okay, so now after you have figured out how much you can realistically pay every month, you want to contact your mediator. Your mediator will be contacting you anyway, so you want to have this conversation with your mediator. Tell your mediator, I can afford to pay X dollars per month. Okay, so it's a fixed amount that you will pay every month until the debt is paid in full. So let your mediator know what the amount is. Now, please note that most creditors want the entire debt to be paid off as soon as possible, usually between 1 to 3 years. Here's a tip that will help you. Okay, suppose your debt is $2,000 and you want to pay $25 per month. Okay, so you want to pay $25 a month until $2,000 is paid off. So divide the total debt by the monthly payment. And it will help you find out how long it will take. So $2,000 divided by $25 per month is 80. So it would take you 80 months or 6 years to pay off $2,000. Now, most creditors are unlikely to accept an offer that would take 6 years to complete. Or suppose you increase your monthly offer and you want to pay $100 per month. So divide the $2,000 by $100 per month and you will get 20. So it would take you 20 months or 1 year and 8 months to pay off the $2,000. Now increase your monthly offer to $200. So now divide 2,000 by 200 and you will get 10. So it would take you 10 months to pay off. Most creditors want you to pay off the debt as soon as possible. And in general, they seem to accept offers where the debt will be paid off within a year or so. If you have been sued, they tend to ask that you pay off your debt before the trial date. Okay, so the higher the monthly payment offer, the more likely they are to accept your installment payment offer. So please do the math. Now choose a payment date. Your installments must be paid on the same date every month. Some people select the first of the month and others select the 15th. The most important thing to remember is that you must have funds available on the due dates. The form of payment will depend on the creditor. They may prefer personal checks, money orders, credit card payments, payments by PayPal, Venmo, Zelle, direct bank deposit. It entirely depends on the creditor. It's what kind of system they have set up. But what's important is that you keep proof of your payments. Most creditors will not send you receipts for the monthly payments. So when you make payments, please keep a printout of your receipts. Next slide, please. The negotiation process. So the negotiation process consists of making an offer and whether the offer is accepted or rejected or a counteroffer is made. And if an agreement is reached, then a written agreement then is reduced to a written agreement. And then we'll talk about the litigated cases. Okay, so once you're sure about your debt settlement payment plan, your mediator will either call or email your creditor to make the offer. So they might call up your creditor and say, I have a client here who's requesting mediation, and she has a debt of $2,000. She's offering to pay you $200 a month. And the starting date is November 1st. She wants to pay on the 1st of every month, and she can make her first payment on November 1st. It would take her 10 months to pay you. So her first payment will be November 1st, 2021. Her 10th and final payment will be August 10th, 2022. So you give this, your mediator will convey this payment plan to the creditor. If your offer is accepted by the creditor, you have an agreement. The agreement needs to be in writing. Either the mediator or the creditor will draft the debt settlement agreement. It will be emailed or mailed to the parties for their signatures. Once you sign it, you send it back to the mediator. The debtor must keep a copy of the agreement and treat it like an instruction sheet and follow through with the payments. If you miss a payment, you will be in default and the creditor may end up suing you. So be careful, make sure you follow your payment plan. Now, if it is a litigated case and you have a payment plan, once you have made all the payments, what the creditor will do is that they have to dismiss the forms. So they dismiss the lawsuit. So they will they will fill out a dismissal form. And so your settlement agreement and the dismissal forms will be filed with the court. So the lawsuit will be dismissed after the payments are complete. Next, please. So sometimes it happens that, you make one-time lump sum payment offer, you make installment payment offers, and your creditor rejects the offers. The creditor is like, it's too low, and you don't have the money to pay more, but you keep negotiating. The mediator goes back and forth, and the creditor keeps asking for more money. They're saying it's not enough money to settle the debt, and so you offer a little bit more, but then you find out that you really can't stretch any further. You really can't offer any more money, and you really, really want to settle the debt. So I've seen in situations like that, sometimes when you talk to the creditor might say, fine, he or she really wants to settle the debt. Maybe the last resource would be, he could write a hardship letter. So the mediator is not going to help you write the hardship letter, because the hardship letter, that would be like advocating for you, and we cannot take sides. But let me tell you a bit about the hardship letter. So in hardship letters, the debtor explains what happened to them and why they missed their payments. So you tell your story. Let the creditor understand that you were not intentionally delinquent, okay? That you had every intention to pay, but something happened. You need to explain what happened. Help them understand, your story about what happened. So notice that I told you earlier today that bill collectors are not interested in knowing your story. Okay, they are only concerned with collecting money. But when you're writing a hardship letter, you are telling them your story. So I'm going to give you an example of a case where, someone really, really wanted to settle a debt, and whatever offer she was making, she didn't have money to make a one-time lump sum offer. So she made installment payment offers, and it was just too low for the creditor. They wouldn't accept it. She kept increasing it a little by little, and I went back and forth, talking to the creditor and making conveying the offers that she was making, and they rejected all of the offers. So then the creditor said, you know what, tell her to write a hardship letter and send it to me, and I will give it to my supervisor. If the supervisor agrees, then we can see if we can work with her offer. So in her letter, the debtor explained that she was, this particular debtor, she said that she was extremely close to her mom. Her mom was involved in a very serious car accident, and her mom's legs were amputated in the accident. And then her mom was in a coma for several months. So the debtor explained that she was a complete wreck, and she became very depressed, and she couldn't get out of bed. But suddenly her mom came out of the coma, and she was very happy, and she was able to function again. So she apologized to the debtors, to the creditors in her hardship letter for missing her payments. She explained that depression made it difficult for her to make good decisions. She included her mom's hospital bills, her photos to support her story. And, in that situation, the creditor agreed to lower her payments. So I don't want to make a false promise that hardship letters always work, but sometimes they do work, like it did for this particular client. Remember that your hardship stories humanize you. It doesn't always work. The creditor may reject your hardship letter and keep insisting in what they want, on the payment that they want. But it is always worth trying. You should always have hope and try your best. So I'm going to end it here. And thank you again for attending. Please let me know if you have any questions. Thank you. So back to you, Christina.
Thank you, Tanzela. Thank you, everyone. We are now in our Q&A session. I want to remind you, if you have any questions, please use the chat box located on the lower right-hand side of your screen. We're going to go ahead and give you a minute so you can type in your questions. I know it might take a while to type it in, so I'll go ahead. Okay, if we could go to the next slide. Just in case you guys have any questions that were not answered or you would like any additional information, you could go ahead and visit us on our website, or you could go ahead and give us a call. The information is on the screen. But once again, we're going to go ahead and give you a couple of minutes to see if you have any questions for us. Okay, Tanzila, we do have a question.
Okay.
What if I am disputing the debt? Disputing the debt.
Okay. If you're disputing, it's like you don't agree that you owe the debt. Is that the question?
Tani, could you clarify the question, please, or resubmit the question? Okay. She's typing it in, this one. Yes, she said that's correct. That's her question.
Okay, so thank you for the question. So you can dispute it two ways. One is that you can say that you are a victim of fraud, like identity theft. So if that's the situation, then mediation isn't the right option for you. We have an investigations department, and we can refer you to them to investigate what happened with your the identity theft situation. But if you're disputing the debt itself, suppose they're saying the creditor says your debt is, $5,000, and you remember that you only spent $3,000 on the credit card bill. So you can dispute that. So what you basically do is you will notify your mediator and say, like, they are suing me for $5,000, but I only remember spending $3,000 with that credit card. So I dispute the remaining $2,000. And so what I would do as a mediator is I would contact the creditor and say she's disputing the remaining $2,000. She said she only spent $3,000. So, and ask them, what's going on, ask them for details. So one of the things your mediator does is, they help convey information, clear up misunderstandings, and they go back and forth with messages. So what happens in cases like this is that creditor will give a breakdown of the debt that they're suing for. So they will, they'll give a breakdown of, the monthly amount that she or he owed, the penalties, the interest, the attorney fees, the court fees. So they'll give a breakdown, and they will give it to me, and I will share it with the debtor so that they can have a better understanding of how they came up with the $5,000 amount and why it's much higher than what she expected. And so that really helps clear up the problem. There have been situations in debt settlement where we have clients who said, they didn't owe X dollars, they owed so much, and then they were able to produce invoices and receipts showing that they actually paid off some part of the debt. So they don't owe, say, 5,000, but rather it's actually 4,000 because they made a $1,000 payment, and maybe the collection agency missed that. So we go back and forth with the message, with the receipts. We notify the creditor, this is what she's saying, and have them look at it. And we've had cases where the creditor agreed and said, yes, I see that you actually paid that. Okay, so I'm bringing down the demand amount to 4,000. So that's how we help them.
Okay, thank you. We do have another question. What steps do mediators take once debt collection case is assigned?
I'm sorry?
What steps do mediators take once the debt collection case is assigned, other than calling the client and learning about the situation?
Okay. So after calling the client, so thank you for the question, first of all. So after calling the clients, introducing yourself to the client, learning about what happened, getting the necessary documents, the mediator is going to help the client work out some kind of payment plan, because that's how you settle debts, you pay it. So they'll talk with the client about how much they're budgeting, how much money they have, how much money they can afford to pay, how much money they can afford to pay for the installment payments, or can they make a one-time lump sum payment. So they work out how much the offer is going to be. So the mediator helps the client work out an offer, but the mediator is always going to tell you, make it realistic. So make it something that you can work with. And so once the client comes up with a payment plan with the amount they can pay, that's when the mediator will contact the creditor and say, this person is offering X dollars. She's offering a one-time lump sum payment of so much, or he's offering to pay X dollars per month and for so many months until it's paid in full. Will you accept the offer? Then the ball is in the creditor's court, who they will say either yes. If they say yes, then you have a settlement agreement, and that agreement will be in writing. Either the mediator will write the agreement, or the creditor will write the agreement. Usually big companies that are creditors, they have boilerplate settlement agreements. They're like 7, 8, 20 pages long. So they will have you just fill in the amount that you're going to settling for, or the mediator here at DCBA will draft it. After the settlement agreement is drafted, if it was a litigated case and there's a lawsuit pending, the creditor will dismiss the lawsuit. But suppose it's a non-litigated case, and then basically they'll keep a copy of the settlement. The client will keep paying the monthly payments until the payment's done in full, and then they're done with it. And after that, usually what happens, and the mediator is not involved in this, but usually what happens is the debtor, after paying up all the debt, will usually contact their credit reporting agencies to notify them that they've paid it off and they want to improve their credit scores. So, but that's something that's not part of the mediation process.
Okay, thank you. We have another question. What if my hardship is ongoing and I really cannot pay?
So thank you for the question. As I mentioned, the hardship letter doesn't always work. It depends on the creditor. Some of them will actually tell you, like, hey, why don't you send a hardship letter? Let me try to talk to my boss. Maybe she will agree. So I've had creditors tell me that. Other times they've said, I don't want to see hardship letters. I'm sorry. I'm not going to consider hardship letters. It just completely depends on them. So, and that is something the mediator has no control over, because that is their decision. The mediation process, the mediator helps you communicate your offers and counter offers and your messages, but they don't control your decisions. The decision is made by the creditor. If the creditor doesn't want to accept it, there isn't much you can do. But what I would suggest, and what I've seen work with my clients, or some of my clients, because it's not always accepted, is that the hardship letter has a lot of details about what really happened to them, why they were not able to pay, and it's kind of makes sense. The story makes sense, and they, kind of validate their story by, including, say, monthly statements, so they can put in their budget, like a monthly budget, and say, look, I have, this is my salary, here's a pay stub, and here's my monthly budget. This is what I spend, monthly expenses. I spend X dollars in utilities and this and that. And so here I have so much left at the end of the month. And this isn't enough to make payments. So they will explain stuff like that, and then they will say, "But I want to make payments. I want to do things right. So please work with me." So some of the time, what I've seen with with some creditors is that when they get the hardship letter, they'll say, "Fine, we really want you to pay, minimum $300 a month, but because your hardship letter was so convincing, how about we give you 3 months to pay $100 a month, but on the fourth month, we need to get $300 per month." So again, that's case by case, and it all depends on the creditor. But it's really the hardship letter, like I said, explain details, follow up with, photographs, medical bills, whatever that is you're comfortable sharing, so that they see that what you're saying is the truth.
Okay, thank you for that. We have another question. A judgment has been ordered in favor of the collection company. What can I do to challenge the judgment if it has been a long time and I just found out?
Okay. So since we're mediators and we're not the small claims counselors, small claims advisors, our department has an excellent unit which is called the Small Claims Advisory. They can help you with that. They can help you with what happens with judgment and what you can do to stop, say, wage garnishment, or they can really tell you. They have the forms, the procedures, and they're experts on that. So I really am not an expert, but basically what I would say is, get the copy of the judgment, and maybe order your latest credit report and just see what's going on, and then contact our office, contact the consumer counselors. Our number is right there, 800-593-8222. Talk to the consumer counselors. They're going to listen to what you have to say, and they will transfer you to the small claims advisor, and you can speak to the small claims advisor and figure out what you want to do next.
Okay, our next question is, can interest rate be reduced while paying off debt?
Yeah, it depends. So what happens is, during the negotiation process, there are many things you can negotiate. You can negotiate anything. It just depends on the parties, whether really the creditor, if they will accept the terms. So, I've mediated cases where the negotiating term was, I'll make these payments, but no interest interests have to be canceled. No penalties, they have to be canceled. I'm not going to pay court fees. I will not pay your attorney fees. So I've done mediations where, the debtor has made those demands. Those are the debts, like, this is what I want as part of the settlement. I'm not going to pay interest. Whatever I paid in the past, I paid, but I'm not going to pay anymore. I'm settling with you. And I've had creditors accept that. They're like, fine, no more interest, just pay on the principal. Yes. So yes, you can definitely negotiate that. You can negotiate anything. It really depends on the parties, whether they will accept it or not.
I believe we have one more question. I cannot afford the judgment on my record. However, I want to settle with the debtor, but my financial situation is not the best. What can be done?
Okay. Thank you. Thank you for your question. And this is pretty common. People come to us, like I said previously, that you come to us a little late. You've been getting threatening letters, and then you got sued. You went to trial, and then you lost, and there was a judgment against you. So what happens in that situation is, if you're not able to pay the judgment, then the creditor may start some kind of collection activity on your account. So some of the things they do is wage garnishment. There is a levy on your bank accounts and stuff like that. And again, I'm not qualified to really go into that in detail because that is what the small claims advisors do. But basically, there'll be some collection activities if you're not able to pay the judgment, and so you can contact our department. And speak to the small claims advisor, and they will definitely refer you to us, the mediation department. So cases like yours that you described, what we do is that we contact the creditor and we tell them, you have this person that you sued, and you won the lawsuit, there's a judgment against her, and it's affecting her credit scores, it's impacting her life, and she wants to, make things right again, and she wants to pay off the judgment. Can we work out a settlement plan? Can we work this out? So many times, the creditor might have waited for, it may have taken years and the creditor didn't get any money and the debt was sold to somebody else. And so they're just losing money. They're not getting any money from you. They might, in those situations, reduce the judgment amount and say, okay, fine, let's settle on, we got a judgment of 5,000. If you give me 4,000, we'll settle. And so then the debtor might say, okay, I don't have $4,000 lying around. Can I pay in installments? So like I said, there's usually these two types of options: one-time lump sum or installments. So you say, I can't pay 4,000, so can I pay in installments? So the mediator goes back and forth between the parties to work out an amount that the creditor is willing to accept. So what usually happens in your type of cases is that there's a payment plan. The debtor keeps making payments, and once the payments are done, the part of the settlement plan could be that, and I've written several like this, where part of the settlement plan was that the debtor negotiated with the creditor, that the creditor, after receiving all the payments, will file a satisfaction of judgment with the court, or they will contact the different credit reporting agencies and notify them in writing that, so and so, I sued this person, and I want you to know that she doesn't owe me that anymore. It's settled. She has paid this, so that they can update your credit report. So that's one of the things that can happen for you.
Okay, we have one more question. Once an agreement is made, who writes it out?
It's a if it's a big company, the creditor is some big, famous, huge company, they will have their own legal team who will have a boilerplate settlement agreement that it's already typed out, and it has, blanks to fill out. And so it is already ready, and basically the terms are agreed upon by the parties, like, I will pay a debt of $5,000, I'll pay $500 per month, and starting on this date, and I will pay on the first of every month until it's paid in full, starting date and the final payment date. Everything, all the main stuff is there. They just fill in the blanks, and that is how the settlement agreement is done. If it's a huge company, they will want to do that. Now, there are companies that don't have that. They don't have those kinds of, boilerplate, ready-made agreements. In that situation, the DCB mediator, will draft it for you. And once we're done drafting, we send it to both parties for review. So you'll look at it and say, oh my God, there's a mistake here, or no, I want to change this, I want to change that, or I want an explanation. So the mediator is there to explain stuff to you, make things clear. You want the language to be clearer, you want to add something. So you'll have that review period where you review it. Both sides will review it. Once both parties agree that the settlement agreement is all good to go, that's when you have the final draft, and then the mediator will email the parties for their signature. So they will sign it, they'll date it, and you email it back to your mediator, and then the other party will also sign it and give it back to the mediator. And what we do is, at our department, we, if you have your cases with Stanley Mosk, the mediator, we will file it for you. So neither party has to go to court.
Okay, thank you. I don't see any more questions, but I just want to remind you that if you can think of any additional questions that were not answered today, or if you would like more information about our services that we provide, you can always contact us using our web address or our telephone number. It is located on the screen. We're going to go ahead and give you one more minute just in case you have any more questions. Okay. Okay, we have one more. What is the percentage rate of these types of calls for mediators?
Calls? Request? How
I'm
many?
assuming, yes, I'm assuming they mean on the debt mediation.
Oh, how many? Actually, I don't know the numbers. My supervisor is in the meeting. Maybe she would know, but I don't think she'll know it offhand. But I know from doing debt settlements, like we get a lot of these. Like, especially I remember last year, just kept doing them, and I was assigning them to other mediators, and I was assigning like 10 of them to each person. So that was a lot. We get a lot of them. But I'm sorry, I don't have an actual number for you. But we are very, very well trained and experienced in handling these types of cases. I hope that helps.
Okay, thank you. Once again, we'll give you another minute just in case you're typing any questions. Okay, so thank you for joining us today. I want to remind you that this webinar will be located on our YouTube channel and also recordings from previous sessions. And we hope you enjoy this webinar, and we hope you enjoy the remainder of your day. And thank you, Tanzila, for answering the questions.
Sure. Thank you, Christina. And thank you, each and every one of you, for attending today's webinar. I hope it was useful and helpful and you learned something new. And please feel free to contact me if you have any more questions. And thank you and have a wonderful rest of the day.